Hi everyone, Dr. K here to talk about the trial process. This lecture actually started out as sort of three topics that I wanted to talk about, and I wasn't sure exactly how to fit them together. So we're going to talk about some disparate things today, and we're going to jump around between topics a little bit. But they all have to do with the process of a criminal trial. So the first thing we're going to talk about is jury selection. How do we decide who gets to serve on a jury? Some of you may have even done jury duty yourselves, so you might be able to chime in on your experience with this. Second, we'll talk about expert testimony, which isn't necessarily something that happens at every trial, but happens quite a bit, and it's been the subject of a great deal of psychological research, especially because sometimes the expert witnesses are themselves psychologists. So we'll talk about how experts are sometimes called upon to educate the court on various issues, and the potential costs and benefits of that system. Third, we're going to talk about prosecutors, specifically prosecutorial misconduct. If you remember from some of the graphs that we've looked at of the causes of wrongful convictions, that's a not uncommon one. Sometimes you'll see it called prosecutorial misconduct, sometimes you'll see it called government misconduct, but it's anything that a prosecutor might do that unfairly influences the outcome of a trial. So we'll talk about how prosecutors deal with DNA evidence that's detrimental to their case, and we'll talk about the safeguards that do or don't exist for holding prosecutors accountable when they do in fact engage in misconduct. So three sort of disparate, loosely linked topics that we'll touch on in the next hour or so. The first one is jury selection. So when a person is charged with a crime and elects to go to trial, the lawyers and the judge have to select some number of people to serve on that jury and make decisions about the case. The Sixth Amendment to the Constitution, for you poli-sci majors out there, says in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So this is an important constitutional protection, right? That we, if we are ever accused of a crime, we have the right to a trial, and we have the right for the jury to be impartial and representative of our community. How exactly do courts go about ensuring that a jury is as impartial as possible? I'm going to ask you to watch this short 2 or 3 minute video which describes that process, and then we will go through it again in a little more detail. So go ahead and hit pause and watch this video. Okay, and we're back. So you now have a little bit better sense of how juries are selected, but let's go through this process again just to make sure we're all clear on how exactly this works. So every one of us is theoretically part of the veneer. The veneer are all of the people who could theoretically get called into jury duty. So if you've ever gotten a summons in the mail that says, hey, you have to come in and do jury duty, you are part of the veneer. And in theory, the veneer is a representative sample of the entire community in the area where this trial is taking place. Now, the goal of the attorneys and the judge is going to be to whittle down the veneer from this huge group of people who are eligible to serve on a jury to the people that they want to serve on the jury in this particular case. So a lot of it is geared toward weeding out people who the court or the attorneys have reason to believe might be unable to be impartial in this particular case. So again, maybe you've experienced this if you've personally been called for jury duty, but sometimes before you even set foot in the courtroom, you'll be asked to fill out a jury questionnaire, which asks you all sorts of questions about your life experiences. If you're curious to see an example of this, there's a link right here you can click that will take you to an example of a jury questionnaire. Basically, this is meant to just make the process more efficient by having members of the veneer provide a bunch of information about themselves. It's possible that, depending on their answers, they may not even be asked to come in the courtroom, or they may not even be, considered eligible for certain trials by virtue of the sorts of things they disclose in that questionnaire. So, for example, you might be asked if anyone in your family has ever been a victim of a certain type of crime. If that's the case, you might be not able to be partial when deciding a case where that type of crime is being considered. You might be asked if if any of your family members are police officers, for example. A attorney might be concerned that might interfere with your ability to be impartial. So you can probably kind of get the sense here that the selection of jurors is really based upon the prosecutor and the defense attorney's instincts about who can and can't be impartial. So the jury questionnaire gets some of that information. Other information comes through a process called voir dire. And voir dire is basically the jury questionnaire, but it takes place in person. And it's often more specialized, catering to the specific details of an individual case. So here you might get questions like, are you acquainted with either of these attorneys? Or do you have any hesitation about convicting someone of a particular crime? So again, it's meant to just collect data from jurors about their own personal beliefs and experiences, and then the attorneys are using that information to decide whether they think the jurors can be impartial or not. As the video you watched in the last slide did a good job of explaining, the process of jury selection isn't so much a process of selecting people, but rather a process of excluding people. And there are two different ways in which attorneys, either the prosecutor or the defense attorney, can exclude people from being on the jury. The first of those two ways is called a challenge for cause. A challenge for cause just means that the attorney has to explain why exactly they have excluded this particular person from serving on the jury. So, for example, if the attorney is concerned that this person's spouse is a police officer, so they won't be able to be impartial, then they can propose that to the judge, and the judge can accept or reject that request. They could challenge someone, for example, because of their own personal history of having been a victim of a crime, right? If I've been a victim of sexual assault, there may be concerns about my ability to be impartial as a juror in a sexual assault trial. So anyway, challenge for cause just means the attorney has to specify why exactly they are excluding this particular person. Contrast that with the other option, which is called a peremptory challenge. Sounds fancy, but all it means is that the attorney doesn't have to give a reason for why they are excluding the person. They just say, I don't want this person, I'm using one of my peremptory challenges, and usually the judge says, say no more, and that person is excluded. Now, each attorney usually gets a limited number of peremptory challenges that they're able to use, but that gives them the ability to exclude a limited number of people from serving on the jury without having to give a reason as to why. And then after all of these exclusions, they'll be left with a trial jury that hopefully is diverse, representative of the population, and hopefully capable of being impartial. Now, as you can imagine, this is kind of a difficult process because a lot of the process kind of relies on asking people to self-report about their own personal biases, which, as you probably can imagine, is not something that people can easily do, right? If you ask someone if they're biased, there's no guarantee that their answer to that question is going to be accurate. So it's hardly a perfect system, but it is the system that we use to exclude people, and whoever's left are the folks that we rely on. Now, I want to go a little bit deeper into talking about the peremptory challenges. Again, as a reminder, the peremptory challenge just means that each attorney at the trial is able to exclude a certain number of people from being on the jury without having to give a reason why. Now, as you probably can imagine, you might be worried about attorneys wanting to take advantage of this system, for example, by excluding people of certain races from being on serving on a jury. In 1986, there was a famous Supreme Court case, which you read about a little bit in the readings for today, called Batson versus Kentucky, where the Supreme Court said it is improper for a attorney to prohibit someone from being on a jury just because of their race. So what that did is it established the ability of the opposing attorney to issue what's called a Batson challenge. In other words, if one attorney excludes, let's say one attorney excludes a black member of the veneer from being on the jury and says, I want to use a peremptory challenge. The other attorney can turn to the judge and say, well, no, I'm challenging that. I'm challenging that on grounds of the Batson ruling because I suspect that this attorney is excluding this person because of their race. So if that happens, that is essentially a way of forcing the attorney to give a reason, right? If there is a suspicion that a person is being excluded just because of their race, that attorney can effectively be forced to give a reason other than the person's race. Now, the question is, in theory, that seems like a good idea, right? Of course, we don't want people being barred from serving on a jury simply because of their race, but do these Batson challenges actually work? And that was the subject of one of the studies that you read for this week by Summers and Norton. In this study, what they did is they had attorneys imagine that they were selecting jurors for a trial, and they were given essentially two jurors to decide between. And both of these jurors were kind of undesirable for different reasons, right? So one of those jurors was a journalist who had written articles about police misconduct. So there's reason to believe that that journalist might favor, might be unable to be impartial. And the other juror was someone who expressed a skepticism of statistics. So again, someone who might be unable to be impartial and difficult to persuade. What they did here, which was kind of clever, is for some attorneys, they described the journalist as black and the skeptic of statistics as white. For other attorneys, they described them as the opposite. So the journalist was white and the statistics skeptic was black. And what they found is that attorneys were more likely to exclude whichever juror was black. But when asked to give a reason for that exclusion, they were likely to cite whichever other thing made the person undesirable as a juror. So this study kind of gives us little reason to have faith that these Batson challenges are actually working, right? What it suggests is that if an attorney really wants to exclude a juror based solely on their race, what they'll do is they'll just find some other justification for excluding that person. And in this case, they chose whichever justification was convenient just so that they could exclude the black juror. So this is a problem, right? This is a problem that does not have an easy solution because, again, we're kind of relying on people being honest, attorneys in this case being honest, about the reasons why they've excluded a particular juror. As it turns out, if they want to exclude a person based on race, sometimes they can get away with doing that, even though it's been ruled unconstitutional. So you may have, your own sort of skepticism about the jury system. The author of this Atlantic article certainly had his own skepticism about the jury system. So he made a few interesting points that you may want to touch on in your posts to the discussion board. The first is that the task that we ask of jurors is kind of unrealistic, right? We ask jurors to be impartial, but we know that juries can't just switch off their biases. Think back to last week when we talked about forensic examiners and how many forensic examiners thought, I could avoid being biased just by choosing to be unbiased and being really thoughtful about it. As it turns out, that's not how it works, right? That's not how implicit bias works. And in fact, we'll come back to this topic next week when we talk about racial bias, which is another bias that we can't just turn off, right? Even if we're aware of it and we're motivated to be unbiased, it's just a byproduct of how our brain works, that we don't have control over this sort of thing. This article also talks a lot about the field of trial consulting, where basically you have people whose job is to help either side, whichever side they're working for, usually the prosecution, help them get an advantage by using social science, social psychology to actually take advantage of jurors' biases in a way that's favorable to whichever side they're working for. Now, as you can probably imagine, these trial consultants are pretty expensive. So the takeaway message, or one of the takeaway messages from this article, is that, at least in the author's view, they would suggest that the trial consulting industry has made the system unfair. The suggestion here is that people who have access to more money are more likely to get a fair trial. Now, you may agree with that, you may not agree with that. I'll be curious to get your thoughts. But that seems to be the author's orientation, is that we're asking jurors to do something that's unreasonable, and what's worse, their ability to be impartial is actually being exploited by these trial consultants who are working for the wealthy, but not so much for people who are disadvantaged. So that's an interesting point to consider, whether the right to a fair trial, while it should extend to everyone, does it in fact extend to everyone equally, or can one buy an advantage in the courtroom? So that puts to bed the topic of jury selection. We're now going to shift gears to our second of our three topics today, which is expert testimony. Now, just to be clear, an expert witness is a person who has expertise in a particular area, who is called upon by the court, sometimes by the prosecution, sometimes by the defense, sometimes directly by the judge, to educate the jury about an issue that is relevant to a particular case. Psychologists, for example, could serve as expert witnesses. If, for example, a psychologist conducted an assessment of a defendant to see whether they were competent to stand trial, or whether they're competent to plead guilty. If you've heard of things like the insanity defense, for example, that might be a situation where an expert witness psychologist would be called in to test this person to see whether they actually meet the criteria for an insanity defense. Expert witnesses could also be forensic scientists, right? As we talked about last week, you might have a shoe print expert take the stand to talk about the analysis that they did and the conclusion that they reached about the shoe prints in this particular case. Now, the sticky thing about expert testimony is we have to draw the line somewhere, right? What makes a person an expert? In other words, how should the court go about deciding who is allowed to testify as an expert and who isn't? Because the last thing we want is just anybody getting into the courtroom. We want to make sure that these people really do have expertise and that their knowledge really will be beneficial to the jury in helping them make a verdict. So what I'm going to show you over the next couple slides is how, over the past century, there have been different criteria used for determining who is and isn't an expert, and therefore who is and isn't allowed to testify as an expert witness at a trial. The oldest test for determining who is or isn't an expert is called the Fry test, and this is based on a Supreme Court case from 1923, where the issue in question, or the issue that was being debated, was whether using blood pressure as a means of detecting deception, so kind of similar to the polygraph, whether that was a reliable way, a scientifically reliable way of determining whether a person was lying. And long story short, this prompted a discussion of, well, when should we consider a person an expert, or when should we consider a piece of science, a type of research sufficiently reliable to be presented in court. And what the Supreme Court decided in 1923 was that the criterion that the court should use was called general acceptance. In other words, if this theory or this methodology is generally accepted within the scientific community, meaning all or the significant majority of scientists in that field all agree that this is a reliable method or a valid theory, then it is reliable enough to be presented in court. So it's a very sort of democratic way of deciding who is an expert, right? If all of or the majority of scientists agree that this is solid evidence, then the court agrees that this is solid evidence. Now, you could imagine situations in which this might be problematic, right? I mean, there was a point in history in which the Earth being flat would have gained general acceptance, and the idea of the Earth being round would not have gained general acceptance. So one criticism of this standard is that it prevents new theories from making it into court, right? It requires a whole lot of evidence and a whole lot of consensus in order for a certain theory to be presented in court. It wasn't until 52 years later that this issue was revisited in what's called the Federal Rules of Evidence, or FRE. And in the FRE, the government essentially laid out a whole bunch of rules for how evidence should or shouldn't be used in court, including evidence that comes in the form of expert testimony. The key phrase from the Federal Rules of Evidence comes in Rule 702, which says that any information that, quote, assists the trier of fact should be considered admissible. So in other words, any information that could hypothetically help the jury make a better decision should be admissible. Now that's very different from general acceptance, right? This is sort of a broader definition of what expert testimony is. Something could potentially assist the jury even if it isn't generally accepted within the scientific community. Now, there are caveats in the Federal Rules of Evidence that says, not just anyone can waltz into the courtroom and testify. Their testimony has to be based on sufficient data and reliable methodologies. But again, it's sort of glossed over that general acceptance part. It's made it seem as though something doesn't necessarily need to be generally accepted in order for it to be presented in court. Now, these two standards kind of contradict each other a little bit, right? So for the next few decades, there was this sort of ambiguity of, well, is general acceptance necessary or is general acceptance not necessary? Should we just consider whether the judge thinks this information will help the jury? This all culminated in a very influential Supreme Court case in 1993 called the Daubert case. And the Daubert case basically wanted to clarify which of the previous standards was the one that we should follow. Should we follow Fry? Should we follow Rule 702? Should we follow some combination of those two things? What once and for all, what is the standard that we should use? And even to this day, different states use different standards. Some states still use the Fry standard. Other states use the Daubert standard, which I'll explain to you in just a minute. So even today, we don't have clear agreement and perfect consensus on this. But the reason that the Daubert ruling was so important is that it tried to really clarify what are the criteria we should use for determining whether a person is or isn't an expert, and therefore whether a person should or shouldn't be allowed to testify in court. Daubert is all about reliability, determining whether a given scientific field or scientific technique is reliable. And that determination is made up to judges. So judges are tasked, under Daubert, judges are tasked with determining whether a given piece of scientific testimony is or isn't reliable. And the Daubert ruling laid out 4 criteria that judges are supposed to use to determine to make that determination. So these are sometimes called the 4 pillars of Daubert. The first one is, can the theory or technique be tested, and has it been tested? So things that are entirely theoretical, that cannot be proven or disproven, would not be admissible under Daubert, right? For those psychologists out there, think about Freud's theory of the unconscious. That could never be presented in court under Daubert because it's not the sort of thing that you can test. It's not the sort of thing that you can prove or disprove. So the first pillar of Daubert basically says in order for something to be able to be presented in court, it has to be able to be proven or disproven. Second, judges are instructed to consider whether this technique or theory has been subjected to peer review and publication. So is this just a theory or technique that one person came up with that no one else has evaluated? Or is it something that actually has been evaluated in a very rigorous way, right? The process of publishing scientific research is really quite demanding. So if something has undergone peer review and has been approved by experts in the field and has been published, that gives it a lot more credibility. Judges are supposed to take that into consideration. The third pillar of Daubert is whether the error rate of the technique is known. This is kind of a tough one, especially in the context of forensic science, which we'll come back to in just a second, right? Theoretically, under Daubert, a fingerprint expert shouldn't be able to testify in court unless we know what the error rate is among fingerprint experts. Sometimes that's a really difficult thing to calculate, right? Think about, again, going back to the insanity defense. Think about a psychologist being asked what their error rate is in determining whether a person is legally insane. That's a very difficult question to answer, maybe even an impossible one to answer. So this is the pillar that I would say is most difficult for scientists to meet, because there are a lot of fields, especially in social science, where calculating error rates is a really hard thing to do. And the fourth pillar of Daubert, which should look familiar, is the technique or theory generally accepted in the relevant scientific community? So the Daubert ruling kept that aspect of Fry, right? Basically what Daubert did is came along and said, general acceptance is important, the Fry ruling is important, but it shouldn't be our only consideration. So what Daubert did is it took the general acceptance standard from the Fry ruling and it added these other 3 considerations to it. So now general acceptance isn't the only consideration, but it is still a relevant consideration. In theory, if a given scientific theory or technique meets these 4 criteria, it should be deemed sufficiently reliable to present in court. Now, as I mentioned a minute ago, the potential problem with this is it sets a very high bar, right? It sets a very high bar for what is considered reliable enough to present in court. And we're going to talk in just a minute about how exactly that bar has been lowered since the Daubert ruling came out. Before we do that, though, I'd like to briefly talk about the judge's role in this determination. Daubert is very clear about the fact that it is the judge's job to determine what is and isn't good science to be presented in the courtroom. Now, the problem with that, or the potential problem with that, is that judges are not scientists. And indeed, judges may not even be trained in how to evaluate science. So we're trusting them to do something that they may or may not be equipped to do. There have been a couple studies in the past 20 years or so that have looked at judges' ability to distinguish between good science and not so good science. And generally speaking, they have shown that judges aren't great. They're okay, but they're not great at distinguishing between good and bad science. So one study in particular in the year 2000 surveyed 380 judges and gave them scientific evidence to evaluate. And what the researchers did is they varied the quality of that evidence, right? Sometimes the evidence, the study was peer-reviewed, sometimes it wasn't. Sometimes it had an obvious flaw in it, sometimes it didn't have an obvious flaw in it. And they wanted to see if judges were sensitive to these things, right? Can they tell when science is not so good and maybe shouldn't be admitted? And what they found is that judges kind of weren't sensitive to some of these things. Whether something was peer-reviewed or not, even though Daubert specifically says that should factor into their decision-making, it actually didn't in this study. What's more concerning is the validity of the study, right? Whether this is, to put it plainly, a good study or a bad study, didn't affect their ability to tell whether it should be admitted or not. A year later, another group of researchers did something similar. They surveyed 400 judges about the 4 different Daubert pillars. So this graph here reiterates the 4 Daubert pillars: whether something is falsifiable, the error rate, peer review and publication, and general acceptance. And what it shows, the different colored bars, show judges' understanding of each of those pillars. Now, judges certainly showed a good understanding of general acceptance, and indeed that was the criterion that they cared about the most when they were deciding whether to admit something or not. They also showed a pretty good understanding of peer review and publication, which again is, a pretty black and white area. Something's either published or it's not. But then with respect to the more scientific criteria of falsifiability and error rate, the judges had a real hard time processing that. A lot of judges in particular didn't understand what it meant for something to be falsifiable, right? What does it mean for something to be able to be proven or disproven? So collectively, these studies kind of suggest pessimism about judges' ability to distinguish between good and bad science, right? The Daubert criteria are, in theory, a really good thing, but we're asking judges to do something that kind of falls outside of their expertise that they may not be able to do all that well. Okay, as I mentioned a minute ago, the Daubert criteria are pretty strict. It sets a very high bar for what should be allowed to be presented in court. But not long after the Daubert ruling came out, another Supreme Court ruling kind of backed away from Daubert a little bit and lowered the bar a little more. That ruling was called the Kumho-Tyer case. And in the Kumho-Tyer case, there was a question over whether a car mechanic should be qualified as an expert, right? So in this particular case, there was some discussion over the quality of a tire and who should be held responsible for a tire failure. And there was a mechanic who had been a mechanic for a very long time, who had analyzed, a whole lot of tires throughout his career. And the one of the sides wanted to have him testify as an expert about the tires that were relevant to this particular case. And if we were strictly applying Daubert, this person would not be allowed to testify, right? They don't meet those criteria of error rates and general acceptance and those sorts of things. But what the Supreme Court ultimately decided was, well, this person is not a scientist, but they are still an expert. And in their opinion, they describe how a non-scientist can still be an expert if they have a tremendous amount of experience in a particular field. So you can see how this is kind of a weakening or a lowering of the bar compared to what the Daubert ruling said, right? Daubert laid out all these very strict scientific criteria that had to be met. And then Kumho basically now is saying, well, an expert is anyone who has a lot of experience in a given field. And ultimately, this mechanic was indeed allowed to testify at the trial as a non-scientific expert. Now, you may be reminded of last week's discussion about forensic science, where in a lot of fields of forensic science, there just isn't a lot of research or scientific evidence to back up the claims and the methodologies that they're presenting. But I'm going to tell you about a case where the court, this is a district court, not the Supreme Court, wrestled with this issue a lot as it pertains to forensic science. So in this particular case, there was a bank robbery that was committed where the bank robber had given a handwritten note to the bank teller and then robbed the bank. So the police had a copy of the bank robber's handwriting from this note that he gave to the bank teller. They then identified a suspect, and they got a handwriting sample from the suspect, and they wanted a handwriting expert, a forensic handwriting expert, to compare the bank robber's handwriting against the suspect's handwriting to see if the expert thought they were or were not written by the same person. And they wanted this handwriting expert to testify in court about this judgment that they had made. This is Judge Nancy Gertner, who wrote the opinion in this case, and it's a really interesting legal opinion to read because you can kind of it's very obvious that she is wrestling between Daubert and Kumo, those two standards, in terms of whether she should allow this person to testify it or not. So the first thing she says in the ruling is there isn't any evidence that handwriting expertise really exists, that it is scientific, right? So she writes, there's no data to say that handwriting analysts can, make a valid conclusion about whether a given person did or didn't write a certain piece of handwriting. There's no validity studies, there's no error rate, there's no general consensus, there's no peer review. So she's just going right down the list here and saying, handwriting analysis as a field does not meet any of the Daubert standards. But then she thinks about it in terms of the at that point it was the recent Kumo ruling, where the Supreme Court said that a person could be not a scientist, but still an expert by virtue of their experience. And she ultimately decided that this handwriting analyst could testify at the trial because they are experts by virtue of their observation and their experience. So merely the fact that this person has analyzed a whole lot of handwriting samples over the course of their career, even though they are not a scientist per se, they are still considered an expert by virtue of their experience. So this case is kind of a good case study on how the Kumo standard really, I don't want to say weakened, but lowered the bar for what is considered expert scientific testimony in court. And a lot of other forensic sciences have since been admissible under that Kumo standard because even though they don't have a lot of scientific evidence to back them up, they do have the momentum of experience and observation for these people to be able to claim that they are experts. Last week, in talking about forensic evidence and forensic science, we saw pretty clearly that cognitive bias can affect forensic scientists' judgments. I don't want to pretend that we're immune from this. There's actually been a couple studies showing that psychologists who act as expert witnesses are also subject to cognitive bias. So in one particular study, and you can see the citation down here if you're curious to read more, Murray et al. 2013, what they did is they got a bunch of very experienced, highly qualified psychologists, and they asked them to do a psychological evaluation of a client. So they gave them all of the materials that they would normally receive if they were working as an expert witness on a case, and they asked these people to essentially score all of these materials, to use these psychological assessments to determine is this person likely to reoffend or not likely to reoffend. The catch is half of those psychologists were told that they were being hired and paid by the prosecution. The others were told that they were being hired and paid by the defense. And what they found was a pretty clear allegiance effect. Even though the psychologists were given the same information, the outcome of their assessment differed depending on which side of the case they were working for. If they were working for the prosecution, they produced a judgment that was more favorable to the prosecution, and vice versa if they were working for the defense. So again, like we saw last week, you give an expert the same information in a slightly different context, and you get a different outcome. Now, it's not exactly clear what causes this allegiance effect, right? Why would psychologists be inclined to produce a judgment that's more favorable to whichever side they're working for? There certainly could be a financial incentive to it, right? This side is the one who's paying me, so I want to make sure that I provide an opinion that's favorable to them. Even if it's not motivated by money, it could just be motivated by loyalty, or maybe the promise of being hired again in the future, right? That maybe there's a subconscious tendency to want to please them so that maybe they'll hire you again. But whatever the reason, it's pretty clear that psychologists conducting evaluations are just as vulnerable to bias as forensic scientists who are evaluating forensic evidence. So then the next question is, are psychologists more aware of their own biases? We saw last week that forensic examiners show a bias blind spot where they see others as biased but do not see themselves as biased. And they also don't think that, they need to be shielded from potentially biasing information. The good news is that psychologists appear to be somewhat less prone to these lack of self-insight. They as you'd expect, psychologists have a better understanding of bias. So in 2018, we did a survey of 1,100 mental health professionals, psychologists, psychiatrists, and so on. And we asked them very similar questions to the questions that we asked the forensic examiners a year earlier. So here we see those three parallel questions that we asked of the forensic examiners, asking about cognitive bias in general, in your discipline, and in yourself personally. And the numbers are consistently higher, right? So with forensic examiners, 71% thought that bias was a problem in general. With the psychologists, 86% thought that bias was a problem in general. So, same thing with asking people about their own personal biases, right? If you remember from last week, only 26% of forensic scientists admitted that they themselves could be biased, but 52%, so twice as many psychologists admitted that they themselves could be biased. That said, there is some evidence of a bias blind spot here. There is some evidence of people thinking that others are more biased than themselves, but it's not nearly as pronounced as it was among the forensic scientists. I won't go through all of these, but here are a few of the other questions that we asked forensic psychologists. I want to focus on question number 2 here, which basically is again asking, whether forensic psychologists are subject to bias. A full 90% of the sample agreed that psychologists can be biased when they are conducting evaluations. Compare that to only 55% of forensic scientists who thought that they could potentially be biased. So again, as one would expect, psychologists are more aware of the issue, but again, that doesn't necessarily translate into them being less biased themselves. So lastly, on the topic of scientific experts, you read a brief piece today called "The Troubling Psychology Behind How We Decide Who's an Expert." there's kind of two major points as I see it raised in this article, and that is that there are biases on both sides, right? So on the one side, jurors themselves have biases. They show confirmation bias such that, an expert who agrees with us, we see as more credible, whereas an expert who disagrees with us, we see as less credible. So again, it's kind of goes back to the whole idea of information that supports what we already believe is information that we like. But information that opposes what we already believe is information that we tend to ignore or try to explain away. The second major point that they hit on is the fact that experts themselves can be biased. And they do kind of talk a little bit about the sorts of studies that we were just discussing in terms of experts showing biases toward their own side. And in my interpretation anyway, the author of this article is arguing that we should go back to the Fry standard of general acceptance. So here's an excerpt from the article. It says, we should trust the scientific community as a whole, but not necessarily any individual scientist. So again, the argument here seems to be that we should go with general acceptance and stop trying to nitpick all this other scientific stuff. I'll be curious to hear if you agree with this or not. And I think, I think a good argument could be made either way. But the idea here is that science should be a democracy, that whatever most scientists believe should be considered reliable, and whatever, only a minority of scientists believe should be not considered reliable. I think that's sort of a controversial position, so I'll be curious to get your thoughts on that. Okay, the third of the three topics that we're going to touch on today has to do with prosecutors. And specifically, I want to focus on situations where prosecutors have to explain away DNA evidence that is detrimental to their case. As we know, DNA is very solid, right? It is the basis for the Innocence Project. It is by far the most scientifically valid of the forensic sciences. So what happens when a prosecutor is trying to build a case against a person and they find that the DNA evidence does not match that person? How do they deal with that situation? I'm going to give you sort of two case studies of this. The first one pertains to the Central Park Five, which is a case that we've touched on here and there, and I'm sure you know a thing or two about from a Netflix show or whatever it might be. But just to be sure we're all on the same page, in the Central Park Five case, 5 juveniles confessed falsely during a lengthy interrogation to the rape and assault of a woman in Central Park in New York in 1989. And they were all convicted, and they all served various amounts of time in prison and were later exonerated. While this case was still very much in the general consciousness, it came out that DNA evidence was recovered from the crime scene, and the DNA did not match any of the 5 boys who had been convicted of this crime. And there's a book called "And the Blood Cried Out." You can see the cover of it here, written by Harlan Levy. And one of the chapters in this book actually gives a narrative account of the prosecutor's reaction when they found out that the DNA test came back and the DNA evidence didn't match any of the 5 boys that they had convicted. So I picked out a few excerpts of sort of that illustrate the prosecutor's reaction to this news that was so devastating to their case. When the DNA results came in, it says the prosecutors dismissed the possibility of attacking the reliability of DNA testing. So, they basically are saying we could go in court and say, well, the DNA must be wrong, but they are not going to do that because they recognize that DNA is very, very solid evidence. So they said, they basically thought, well, we're going to come off as incredible if we go in there and try to convince the jury that DNA is wrong, and we could be doing ourselves a disservice for future cases where we're trying to use DNA to get convictions. So we don't want to shoot ourselves in the foot. So what are we going to do instead, right? And what they say is that they want to make an argument where the DNA could be right, but the confessions could also still be right. So here you can see at the bottom of this excerpt, right, where it says Lederer, who was one of the prosecutors, said about developing a theory to explain why the DNA was still correct, but these 5 boys are still guilty. In other words, how can both the DNA and the confessions be true? And what they ultimately came up with was an explanation that there were more than 5 people who assaulted the woman. So while all 5 of these boys confessed, so they are definitely guilty, but there must have been other people who also were with them that we didn't catch. That was the theory that the prosecutors came up with and presented to the jury of how both the DNA and the confessions could be correct. I will leave it to your own judgment as to whether that is a plausible theory or not. But as we'll see over the next couple slides, the theories get a lot less plausible from here on out. You read an article for today called The Prosecution's Case Against DNA, which talks generally about cases like this, but mostly focuses on the wrongful conviction of a man named Juan Rivera, who was incarcerated for 19 years before being exonerated in 2012 for a rape and murder that he did not commit, a rape and murder of an 11-year-old girl. If you haven't already, I encourage you to watch some of the video on this website. I've picked out a 3-minute segment that I think is particularly worth watching. So I'm going to give you a pause right now to go ahead and watch that if you so choose. All right, so the takeaway message here really is that prosecutors who are faced with DNA evidence that is detrimental to their case are often forced to come up with creative, that's one word for it, I would use the word bullshit, theories to explain why the DNA can still be correct, but the person who confessed is still guilty. So in this particular case, as you saw in the video, Juan Rivera had given a coerced confession, but the DNA recovered from the 11-year-old girl who was raped did not match Juan Rivera. And the theory that the prosecutor in this case, Mike Mermel, proposed is that the 11-year-old girl had consensual sex with someone else earlier in the same day that she was raped by Juan Rivera. So the DNA belonged to the man that she had consensual sex with, but then Juan Rivera still was guilty of the rape, as evidenced by his confession. Again, I will leave it to you to decide how plausible you think that is, but the jury in this particular case seemed to buy it. Now, taking a step back for a second, the culture surrounding prosecutors is, as they describe it in this article, a culture that values winning over justice. The goal of a prosecutor is to win the case. It is an inherently adversarial system. They don't get a bonus for finding the truth if it means that they lose the case, right? And we could easily have a discussion about that incentive structure and how that might impact their behavior. But unfortunately, that's the reality of things, right? Prosecutors are concerned with their conviction rate. They're not necessarily always concerned with getting the truth. So as even further evidence of that, let's talk a little more about the various theories that prosecutors have used to explain away DNA evidence that harms their case. We just talked about the Central Park 5 case. This is Linda Fairstein. She was the prosecutor in the Central Park 5 case. She, as an aside, she has faced a lot of backlash, deservedly so, about how she handled that case. She was the one who concocted this theory about how, you know, the 5 boys are still guilty, but the DNA suggests there must be others who we didn't catch who were also guilty. She was a adjunct professor at Columbia Law School who was who basically was forced out because there was such a backlash against her. She is currently suing Netflix for character defamation because of how she was portrayed in the series When They See Us. So that'll be an interesting one to follow. Mike Mermel, you saw in the Juan Rivera video. He was the prosecutor in Juan Rivera who came up with this theory about the 11-year-old girl having prior consensual sex with someone. If you've seen the Netflix show Making a Murderer, this is Ken Kratz. Very, very slimy guy. If you haven't seen it, I promise you'll be repulsed by him when you do watch this show. He is the prosecutor who's responsible for the fact that Brendan Dassey and Stephen Avery, the protagonists of Making a Murderer, are both currently incarcerated and overwhelmingly likely to be innocent. And I also want to tell you about Anita Alvarez. I'm going to hold off on her for just a minute, but she is another prosecutor. So just to give you a taste of how prosecutors try to explain away DNA evidence, I'm going to tell you about 4 theories that have been proposed in court by prosecutors who were charged with the task of reconciling DNA evidence from one person and confession evidence from a different person. We've already seen one of these. Mike Mermel, you know, and you might have even seen this in the video on the New York Times website, the unindicted co-ejaculator theory. It's basically the idea that in a rape case, a prosecutor may argue that the reason that the DNA doesn't match the person who confessed is because the victim of the rape had prior consensual sex with someone else. So the DNA matches that person, but the confessor is still the rapist. Therefore, there's no contradiction, and the court should still convict the confessor. In a minute, we're going to see a study that actually tested that, but the long and short of it is, jurors often find that argument persuasive, as crazy as it may sound, when they hear it in court. In a case in Florida where a man named Wilton Dedge was on trial, it was a rape case where they found a pubic hair that did not match Wilton Dedge. The prosecutor argued that the pubic hair actually came from the moving company that had moved the victim's stuff into her apartment. That I guess the movers were not wearing pants when they, I swear I'm not making this up, were not wearing pants when they were moving the victim's belongings into her apartment. So yes, there was a pubic hair that did not belong to the man who confessed, but that pubic hair came from the movers, and the defendant, in this case Wilton Dedge, still is guilty in their estimation. This is a pretty crazy one. So, Jerry Hobbs in Illinois, another rape case. A woman was raped in the woods. They found DNA that did not match Jerry Hobbs. Now, in this particular case, the victim, it's as sad as it is to say this, the girl that was raped was only 8 years old. So it wouldn't really make a whole lot of sense to say that she had consensual sex with someone earlier that day. So the prosecution had to get even more creative when they found that the sperm that was found on the girl did not match Mr. Hobbs, who had confessed. So the theory that they came up with was that another man had gone out into the woods earlier that day just to masturbate in the woods, left his semen in the woods, that then Jerry Hobbs just so happened to rape this 8-year-old girl in the exact same spot where the other gentleman had masturbated in the woods earlier that day. Doesn't make a whole lot of sense. And as you're probably getting the sense, these prosecutorial theories are often very, very cockamamie bullshit theories. The fourth one, though, might be my absolute favorite, and this is where we get back to Anita Alvarez. I'm going to let you watch the video so you can see this in your own words, but Prosecutor Alvarez presented a theory that a man raped and murdered a woman, but then his DNA didn't match the DNA that was found in the woman, because later that day, a person who was into necrophilia just so happened to walk by the woman's dead body, and that person raped her also. Go ahead and I'll pause so you can watch the video that's linked up here for just these 2 minutes, and you can kind of see what Mrs. Alvarez's thought process is. All right, are you sufficiently disillusioned by all of these crazy prosecutor theories? Now, they obviously sound ridiculous, right? And you may be wondering, how could anybody possibly believe this? Well, there actually is a study, just the one study that I'm aware of, but it's a good study where they wanted to see if juries will actually buy these arguments. So here's what they did. They took a sample of mock jurors and they presented those jurors with DNA and confession evidence. Now, in some cases, the DNA and the confession both implicated the same person. In some cases, one of them implicated that person and the other one did not. So the question that these researchers wanted to get at is, if the DNA and the confession contradict each other, what do juries trust? Here's a graph showing their results, and I'm going to walk you through it one bar at a time. We're going to start with this bar on the left, okay? This is a group of jurors that was told that this person confessed and the DNA matched this person. So both the confession and the DNA both implicate the same individual, and when that is the case, nearly everyone said, okay, this person must be guilty, and they voted to convict that person. That is certainly the logical thing to do. If the suspect gave a confession, but the DNA implicated someone else, so if those two pieces of evidence contradicted each other, which one do jurors trust? Jurors actually trusted the DNA, which again is a good thing, right? Only 10% of people were willing to convict someone who confessed if the DNA pointed to someone else. So in short, they trusted the DNA over the confession, which again, I would argue, is the logical thing to do. However, here's where this study gets a little pessimistic. If the suspect confessed to the crime and the DNA did not match that person, juries convicted that person only 10% of the time. But if they were also given a theory, like one of the theories that we talked about on the previous slide, that seemingly reconciled the confession with the non-matching DNA, the conviction rate jumped to 33%. So it more than tripled. It went from 10% to 33%. When jurors heard one of these cockamamie theories that we talked about on the previous slide. So if you're wondering why do prosecutors use these theories, it's because they kind of work. Juries kind of believe them and become more likely to trust the confession, even if the DNA contradicts the confession, because they're offering an explanation, even an extremely implausible one, as to why the confessor could still be guilty. I want to end today, we're kind of wrapping up now. I want to end today by telling you about a particularly tragic case. You know, a lot of the cases that we talk about in here have relatively happy endings where, you know, the person is exonerated or is never convicted in the first place. The cases that we're going to see over the next couple weeks are increasingly sad, and this is maybe one of the saddest in my personal opinion. Billy Wayne Cope is a man who lived in South Carolina, and he woke up one day in his own home and found that his daughter, his 12-year-old daughter Amanda, had been raped and murdered in her bedroom. And there was no indication that anyone had broken into the house. Because there was no indication of broken windows or broken locks or anything like that, police decided that Billy, the father himself, was a suspect in his own daughter's rape and murder. And they ended up interrogating him, despite the fact that he suffers from a pretty clear intellectual disability. Interrogated him over the course of 4 days for a total of 17 hours, during which time he, and it's all on videotape, he denied guilt over 650 times. So consistently maintaining his innocence. He actually volunteered to take a polygraph test, thinking that it would prove his innocence. But he was told that he failed the polygraph test, which actually was not true. So he volunteered to take a polygraph test, took it, passed it, but then the interrogators told him that he failed it. So not dissimilar from the Michael Crow case that we've talked about a few times previously, Billy Wayne Cope actually forms an internalized false confession, comes to believe that he actually did rape and murder his own daughter and that he just doesn't remember it, and confessed on 3 different occasions, actually, and gave confessions that do not line up at all. They're very inconsistent with each other, and with the details of the crime scene. So Cope goes to trial, and while he is awaiting trial, the DNA evidence from the victim is tested. And the DNA matches a man who has prior convictions for burglary and rape, who had just moved into the neighborhood and lived 2 blocks away from the Cope family's home. So the prosecutors are faced with a similar situation, right? We have a man who has confessed, and we have another man whose DNA matches the semen found on the victim. So what ultimately happens is the prosecutor argues that Billy Wayne Cope actually let the man into his home so that he could rape and kill his daughter. So the theory was that the two were sort of in cahoots with each other, despite the fact that there was no evidence whatsoever to suggest that they had even ever met, let alone conspired in this way. And that theory was good enough for the jury to convict Billy Wayne. He was convicted in 2002, and his case went through all sorts of appeals, even all the way up to the Supreme Court. And what's really sad about this case is not only did the Supreme Court decline to give him an appeal, but Billy Wayne Cope actually passed away in prison. So he served 15 years in prison and passed away while incarcerated. Very, very sad case. It sounds insensitive to call it interesting, but it is a very compelling case, because I cannot think of a case where the man's innocence has been more obvious, yet it still had a very sad ending. So if anyone is looking for ideas for their final case report, this would be quite a good one, I think, to tackle. Unfortunately, this video link no longer works, but there is a episode of NBC's Dateline, I think, about this case if you're curious about learning more. But by this point, in the lecture, and this is the last slide, by this point in the lecture, you're probably very frustrated with all of these prosecutors and their sort of irresponsible behavior. And I wish I could end on an optimistic note, but unfortunately I can't, because as it turns out, despite prosecutorial misconduct being a cause of wrongful convictions, they're very, very, very infrequently punished for misconduct. If you're curious to listen to this story, there's a good 5-minute podcast of sorts in WNYC News. You can just Google this headline and it'll come up. But here's sort of the takeaway message is that the Innocence Project did an analysis where they looked at 660 cases where prosecutors were determined to have broken the law, actually engaged in illegal misconduct in court cases. And what they found was that only one of those 660 cases did the prosecutors actually face consequences for their misconduct, which is very troubling. So, again, some of the themes that we keep coming back to in this course are transparency and accountability. This is a situation where we clearly do not have accountability, and it's not an easy fix, unfortunately. So anyway, that should shed some light on the trial process, from the jury selection process to the expert testimony to prosecutorial arguments. I hope you look forward to talking about this on the message board. I think there's a lot to discuss here, and I look forward to hearing your thoughts. See you later.